So welcome everyone to today's session, the impact of race and culture assessments, IRCAs, improving justice outcomes for Black and racialized persons. My name's Candice Fenna and I'm one of your moderators today. I am joined by my colleague here, Andrew Fairburn. Before we get started, I'm going to review some quick housekeeping notes and then I will introduce our speakers today and begin the session. I'd like to draw your attention to the bottom of the screen. You can use the chat feature through this session to submit questions. We ask that you please type question in all caps in the chat so it makes us easier to find your questions. The presenters will be taking questions at the end, so you can type them throughout, but we will be addressing those once their presentation wraps up. And we're going to do our best to get through as many questions as we can. Please ensure your microphone is on mute, of course, until the Q&A portion of the session. Please note that we are recording this session and we're going to be uploading all of our concurrent sessions to the website for future viewing for those who have already registered for the conference, and that'll be available to folks 90 days following the conference. We kindly ask that you complete a short evaluation at the end of the session. Your feedback really is appreciated by us and of course for the speakers. Lastly, we'd ask you to be respectful today, attending today's session. Please engage with each other in a thoughtful way. Always consider the impact of your words and your interactions with others. As moderators, we will not tolerate any abusive or inappropriate behavior in the session, and we will ensure that anyone who engages in this behavior is removed from the session. With that, I'd like to introduce our presenters. Kimberly Roach, she is Policy Counsel at Legal Aid Ontario. AJ Grant Nicholson, who is principal at his own firm, Grant Nicholson Law, and is also a mental health and justice advisor. Over to you, Kimberly and AJ.
Thank you, Candice. I'm really thankful for the opportunity, and I'm sure AJ is as well, to discuss impact of race and cultural assessment reports with you today. These reports are also called enhanced pre-sentencing reports, or also Morris reports, and that speaks to the case, the leading case that approved the use of these reports in criminal matters. Now, impact of race and cultural assessment reports, which I'll be referring to as IRCAs, are important tools in moving further towards more equitable outcomes for members of Black, racial, and racialized communities who come into contact with the justice system. IRCAs are currently used at the sentencing phase of a criminal proceeding. So that is after there has been a finding of guilt and the court has to turn its mind to a fit and proportional sentence for the offender. The existence of these reports has made it more apparent, I think, to social and justice sector participants that there is a need to learn more about the intersections of race, mental health, and the criminal justice system. My co-presenter, AJ, will speak about some of the structural barriers that are faced by Black and racialized persons when accessing mental health services and how those barriers may impact criminal law proceedings. What are IRCAs? Impact of race and cultural assessment reports are reports that are used for Black and other racialized adults and youth during the sentencing phase of a criminal matter. They are important tools that help the court to understand how systemic racism has influenced a person's life, their circumstances, and how they find themselves or why they find themselves in front of the court. The reports often are helpful because they focused on the individual's life circumstances, and they're also considered in conjunction with another report, which is called the Expert Report on Crime. And I'll talk a little bit more about that later on. But these reports, in addition to providing information about the individual's circumstances and experiences which may have resulted in them being before the court, they also suggest better options than putting someone into custody. They can recommend conditional sentences, but they also can speak to what type of programs or accountability measures should be put into a sentence in addition to incarceration. So it may speak more to reintegration if the person is incarcerated. And all of this helps to make the sentence for the individual more fit and proportional, which is an equitable outcome. Who prepares the IRCA reports? IRCAs in Ontario are written by people who we call IRCA writers. They are trained in and around the issues of anti-Black racism. This allows them to be able to obtain the required information from individuals in a trauma-informed manner. Oftentimes, individuals who are either detained and waiting for their sentence, you know, have gone through a significant amount of issues in their life that may be the result of anti-Black racism in various areas of society, and that discussing those things can bring up a lot of trauma. And so the writers that often do this type of work often have a background in social work, psychology, or education. Most of the reports in Ontario are prepared by a nonprofit group called the Sentence and Parole Project. And there has been a significant increase in the demand for IRCA reports since 2017 when LEO first started to fund these reports. And as a result, there's a growing need to recruit and train more IRCA writers. So that's something that has been identified as an area that we need to kind of bolster and make sure that there is an increased amount of IRCA writers who can meet the demand that we're currently seeing. In terms of eligibility, as a result of funding from the federal government and the provincial government, IRCAs are now available to a larger amount of people than they first were in 2017. Right now, an adult who has a legal age certificate and identifies as Black and is facing more than 2 years in jail is eligible to receive funding for an IRCA report. Additionally, a young person between 12 and 14 who identifies as Black, has a legal aid certificate, and faces a custodial sentence, and this can be open custody or closed custody, is also eligible to receive funding for an IRCA report. Those who are not legally aided and adults who are facing sentences of less than 2 years incarceration may be eligible to receive an IRCA where there is a court endorsement. So the court would have to make an endorsement to have an IRCA produced, and those individuals would then be able to access an IRCA. Why are IRCA reports needed? Well, several reasons. Canada is not immune to racism. I think that very much of Canada's history has talked about Canada as being a mosaic, of being welcoming of differences. And we know that that picture is not an accurate picture of Canada's history. And so, anti-Black racism is present in all sectors of Canadian society. The findings of the expert report, Experiences of Black Canadians in Toronto, Ontario, which is the report that I mentioned earlier, outlines anti-Black racism in a variety of ways and a variety of society, various parts of society, and how it impacts Toronto's Black community. It also specifically outlines a number of reports as secondary sources, and outlines how anti-Black racism presents itself in Toronto specifically. We know that there is, in terms of anti-Black racism and racism in general, Ontario's low-income population, Black and racialized people are overrepresented in the low-income population. We also know that in terms of children in care, in Toronto, Black children are overrepresented in care. In other parts of Ontario, it seems to be racialized children are overrepresented in care. In terms of housing as well, Black and racialized communities are often overrepresented amongst those who are homeless, precariously housed, or in low-income housing. We know that there are disparities in education, and specifically disparities in how school discipline is actually how it occurs. So higher rates of suspensions and expulsions for Black students, and also for some other racialized students. Employment as well. Black and racialized people tend to earn, I believe for Black women, it was 77 cents per dollar that is earned by someone who is white. And we also know that there are disparities in health, and I think that AJ will get into that a little bit later on. More significant, I think, as for why we have IRCAs, is the racism and racial disparities that we see within the criminal justice system. We know that there is an overrepresentation of Black persons who are incarcerated in Canada and in Ontario. But we also know that that overrepresentation extends beyond incarceration. It's at all levels of the justice system. It starts with over-scrutiny. So Black people, and often racialized people in areas outside of Toronto, are often subjected to higher scrutiny and increased surveillance by law enforcement officials in public spaces such as highways, streets, malls, and borders. In terms of this over scrutiny, it can also result in bias in policing. And sometimes what we see is that members of Black and racialized communities are more likely to be detained at the scene. And we know that bias in policing may impact how the accused is perceived. Actions that are often viewed as the result of mental health conditions or struggles with addiction. For individuals who are white, may be seen as behavioral issues or inherent criminality when the person is Black or racialized. We know that the treatment is also very much different for Black and racialized individuals with mental health. And there have been a number of cases, I believe, that that the media has reported on, that have shown this. For example, health checks. There have been a number of cases where family members have sought the help of police in the form of wellness checks, only to have their individuals, their loved ones, either significantly injured in the course of those wellness checks or end up dying. There are higher rates of arrest. And again, this may be linked back to the higher rates of scrutiny of neighborhoods that tend to be higher in Black and racialized populations. But as compared to white people, minorities are, and when I say minorities, I mean Black and racialized people, are more likely to be arrested, convicted, and punished. And we also know that there is an increased likelihood of members of racialized communities who come into contact with the police to have those interactions with police evolve into violent confrontations, which result in injuries and even loss of life. In terms of pretrial detention, we also know that Black accused, after controlling for all variables, tend to receive significantly more conditions than non-Black accused. And they are subject to greater surveillance by the courts, so curfews and mandatory supervision requirements. So those are some of the things that IRCAs are aiming to kind of address within the justice system. In terms of intersectionality, I think it's important that we talk about that the fact that people have identities that are complex. Race and mental health can impact the treatment that you receive. And we know that individuals with mental health conditions are also overrepresented within the criminal justice system. For example, the mental health and addiction needs are present throughout the justice system and throughout corrections, and as well throughout the population that is eligible to receive legal aid services. We know there's enough reports that show that people with mental health issues are disproportionately criminalized, incarcerated, impoverished, underhoused, all of which present advocacy issues within legal aid's mandate. Racialized inmates, we know that they are disproportionately represented amongst prisoners who are charged with rule violations, especially when it comes to subjective judgment. And all of this, I think, has to do with stereotyping and bias. We know that Black individuals with mental health conditions like schizophrenia, bipolar disorders are more likely to end up in jails as compared to people of other racialized backgrounds. We know that from the studies that the government has put out, that, there are studies that show that there is unfair treatment and discrimination against racialized individuals in prison. We talked about the fact that there's a disproportionate amount of racialized prisoners that are charged with violations that are subjective. So again, they're more based on the opinions of the guards, and not something that can be definitively shown. It's subjective. And what we've learned from some of the reports produced by Howard Sapers and the federal government is that some behaviors of Black prisoners, which might be considered cultural, are wrongly stereotyped as being aggressive. And this bias also impacts how their mental health is perceived. Again, behaviors that are traditionally viewed as indicative of mental health concerns among non-Black prisoners were viewed as aggression when they were associated with Black prisoners. Now, legal aid has a role in making the justice system fairer for Black people and for racialized people in general. Legal Aid Ontario's mandate is to provide high-quality legal aid services to low-income individuals and promote access to justice for low-income individuals. We do this by identifying, assessing, and recognizing the diverse needs of low-income individuals and what we've called historically disadvantaged or marginalized communities. We talked about the fact that Black and racialized people are overrepresented in Ontario's low-income population. And so, a part of our clientele is significantly racialized. And also, I believe it was one in 3 people that have LAO certificates are also struggling with mental health issues. Now, meeting our mandate requires that we address the impact of anti-Black racism in the legal system, and particularly in the criminal justice system. And LAO support of IRCAs for Black individuals facing criminal charges is just one way in which we try to fulfill our mandate. LAO also helps lawyers to learn how to make race-based submissions. We prepare memos, and we also support test cases that challenge things such as racial profiling or other issues where we feel that there are significant disparities in the application of laws. One example of this is mandatory minimums. We know that these types of cases disproportionately impact Indigenous, Black, racialized, and other vulnerable low-income communities, such as those who struggle with mental health. In terms of the law, so IRCAs, the IRCA reports are grounded in law, and the specific law that I'm speaking about is Section 718.2E of the Canadian Criminal Code. This law requires that the courts use the principle of restraint when considering a sentence. Specifically, it's a direction that the court use restraint in respect to imprisonment as a sanction. It indicates that a court should consider other sanctions whenever it is reasonable to do so. It also requires the court to consider mitigating factors, and these are things that might make a person less responsible for their actions. So these can include social, economic, or political issues, which implicate the government in having some responsibility to the community or to the circumstances of the individual. This also includes what is broadly considered or called social context evidence. And after 718.2E was put into place, there was a case called the Crown versus Gladue, which went to the Supreme Court. And this case involved an Indigenous woman. The case recognized the impact of racism. In fact, the Supreme Court of Canada said courts must take into consideration or take judicial notice of such matters such as the history of colonialism, displacement, and residential schools, and how that history continues to translate into lower educational attainment, lower income, higher unemployment, higher rates of substance abuse and suicide, and of course, higher levels of incarceration of Indigenous peoples. Social context on its own does not necessarily justify a different sentence than incarceration for an offender, but it does provide the necessary context for understanding and evaluating the case-specific information that's presented by counsel. And that's really what the impact of race and cultural assessment reports are trying to do for Black and racialized individuals, providing that context. In Gladue, the section of the Act also sets up the requirement to consider systemic issues such as social disadvantage, particularly where the individual is Indigenous and before the court. But though Gladue spoke specifically of the Indigenous experience, starting in the early 2000s, I want to say it's 2008, defense counsel started to argue that under Section 718.2E, the court should be taking judicial notice or recognizing the social context and the disadvantage that results to members of the Black community as a result of anti-Black racism and other historic policies that were based in anti-Black racism. So, for example, segregated schooling, segregation in general, and the history of policies that resulted in over-policing of Black and racialized neighborhoods. Specifically, council were seeking that the court look at how that history of racism that continues, but how it translates into lower educational attainment, lower incomes, higher employment, higher unemployment, and greater levels of incarceration for members of the Black community. There are a number of cases where that kind of put this argument forward, and slowly incremental changes occurred. One of these cases, and I'm sorry I'm wrong, it was 2004, not 2008. But one of the first cases was R versus Hamilton, and in that case, counsel put forth the argument that the court needed to consider systemic and background factors that related to gender, racial bias, in order to mitigate the sentence for Black Black offenders in general, but in this particular case, for Miss Hamilton, who was a young Black woman. In that case, the trial judge kind of conducted his own research into systemic racial and gender biases, and did decide that he was going to set aside he was going to put in place a conditional sentence. That case was appealed and overturned, basically not because the higher court didn't believe that that systemic anti-Black racism should be considered, but because of how the trial judge went about gaining that evidence of systemic discrimination. In the leading case that approved and promotes the use of IRCAs for Black individuals. So the case that went to trial in, I believe, 2017, and then was appealed by the Crown, and the decision came out in March 2021. And in this matter, the Court of Appeal, a panel of 5 judges, basically said that sentencing judges need to put more emphasis on the significant role that social context plays in lowering the degree of responsibility of an offender. The court recognized that there was a need to acknowledge, confront, mitigate, and ultimately eliminate anti-Black racism in society. The other thing is that the court found that it was essential to look at how racism affects the person and their community in order for the court to arrive at a fit and a proportional sentence. These IRCA reports were considered to be essential and important. Another case that came out shortly after was R.V. Kelly. And again, sorry, I'm just realizing there's an error in the deck. But the IRCA report that was presented to the court helped the judge to consider the fact that there is an over-incarceration of Black people within the justice system, and how he could apply the principle of restraint in this matter. Instead of incarceration, Ms. Kelly was given a conditional sentence a conditional sentence was imposed And the conditional sentence in her case was seen as being fit and proportional because of several mitigating factors. They looked at her age, some of the mental health related trauma that she had gone through while this matter was before the court, her personal circumstances in terms of being of lower income. So her age at the time of the offense and her role, and the fact that she had no criminal history. All of this, she exhibited remorse, and she had faced disadvantage and systemic anti-Black racism. And so the court factored all of those things and decided that this was not a matter that called for incarceration. Rather, it was a matter where conditional sentence was more appropriate. A recent case, which is a 2023 case, is the case of R versus Vaughn Roberts. And in that case, again, the IRCA helped to ensure that the justice system considered Mr. Roberts' background, considered the role that race and racism played in the charges that he was facing, and decided and those things were considered as important to crafting a fit sentence. Now, Mr. Roberts' court case was interesting because this was a young 22-year-old male who had been charged with discharging a firearm. And the person who he had discharged the firearm towards did end up dying. But what was also at play was that there was a race-based plot against Mr. Roberts by the individual who was later shot. And that was factored, that the fact that there was the circumstances that Mr. Roberts found himself in the fact that race and anti-Black racism played a role in what resulted was taken into consideration by the court. And they were able to craft a sentence that promoted accountability, but also took into consideration all aspects of the case. AJ?
Thanks, Kim. So I just wanted to, add to Kim's presentation and just discuss the impact of racism and discrimination on mental health and health overall. Kim did a great job of addressing how racism can impact a person's access to justice and healthcare, as well as other social determinants of health, like housing and income. I just wanted to make a note that it's important to keep in mind that anti-Black racism negatively impacts overall health, including mental health. And this is something that there's growing recognition of. Psychiatrists in various countries have noted that the impact of structural and institutional racism are a risk factor for developing mental illness. Furthermore, there's been studies that have shown that chronic stress related to experiencing racism can be extremely toxic for the body. Prolonged elevation of stress hormones in our bodies can be toxic and can compromise our body's ability to regulate key biological systems like the cardiovascular system, the inflammatory system, and the neuroendocrine system. Also, racism itself can worsen symptoms of pre-existing mental illness. So if we're thinking about an accused person who's Black going through the justice system and the mental health system, if they're experiencing racism, it could worsen pre-existing symptoms, such as paranoia. It's also important to consider it specifically in the justice system context. So if we're thinking about the impact of racism on mental health, consider how racial profiling and over-policing, again, can contribute to anxiety and paranoia. And think about, again, I think Kim touched on this, overrepresentation of Black inmates in the justice system being incarcerated, its impact on their health and mental health. So I think, it's important to look at, how access to justice and healthcare can be negatively impacted by racism. But it's also important to keep in mind that racism itself is deleterious or very harmful to the health of Black persons. Okay, just want to move on to the next slide. So a little bit about myself. I'm a lawyer. I used to work at Legal Aid Ontario as a staff lawyer. And one of my first jobs at Legal Aid Ontario as a mental health law staff lawyer was to work as a duty counsel in a forensic mental health hospital. So a large regional psychiatric hospital that had forensic mental health units. I've also worked as a policy counsel at Legal Aid Ontario. And in my practice, I do consulting work as a mental health and justice advisor. And I also do work in criminal mental health law, where I represent accused persons before the Ontario Review Board. So what I can say from my experiences is that there's a concern that Black persons in the forensic system, that is, accused persons under the Ontario Review Board's jurisdiction, are overrepresented and are treated differently than other groups. Some further background. So the forensic mental health system covers persons who've been found not criminally responsible of a criminal charge because of what the criminal code defines as a mental disorder, or it's persons who've been unfit to stand trial. So they end up under forensic mental health care. And again, what a lot of stakeholders will tell you is that what they see anecdotally is overrepresentation, particularly of Black men, as compared to other groups, and that there's concern that they're treated differently than other groups. One study has found that the use of restraints for Black patients at a psychiatric hospital that has a forensic unit was 44% higher than compared to white patients. And that's very, very concerning and reflects the concern about the different treatment that some forensic Black patients have. It's important to consider how barriers to accessing mental health care impact the pathways of Black persons experiencing mental health in the justice system, as well as their outcomes in the forensic system. So as Kim spoke to, there are systemic issues that might contribute to the different treatment or differential treatment of Black accused persons in the forensic system, as well as their overrepresentation. And that's important to consider when addressing this issue. It's also important to think about ways to address it and think about the pathways of persons in the forensic mental health system. Sorry, can we just go back to the previous slide? So when we think about the forensic mental health system and pathways, the objective ultimately is to get an absolute discharge. And it's been my experience that, systemic issues can impact a person's ability to get a discharge in a timely manner. If we think about, the goals of getting a discharge, it often is step by step. Accused persons go to the Ontario Review Board. The Review Board does an annual review. They get a report from the hospital that looks at, how they've been at the hospital, issues with discipline, behaviors at the hospital. And what they're really looking at is whether or not the person can be discharged into the community, bearing in mind paramount consideration is public safety. So they might, try the person on passes. They might try the person in community living, but still under the Ontario Review Board's jurisdiction. So if we're talking about a Black accused person that has issues with accessing housing, that might have issues with getting access to mental health supports in the community, or facing discrimination in terms of over-policing and harassment, that can impact their ability to get that conditional discharge. We also need to think about, interpersonal conflicts on the units. in my experience, I've had clients that complain about interpersonal conflicts with other co-patients, where racial epithets are used, there's conflict, and then there has to be use of seclusion or restraint to resolve the conflict. So these are things that need to be looked at and considered for Black patients in particular, given some of the concerns that I've already spoken about, that a lot of stakeholders are seeing in terms of different treatment. And it is important, to think about perhaps further study into this issue. So it's not just based on, what stakeholders can point to anecdotally, but there's actually numbers behind it. Okay, can we go to the next slide, please? So practical realities. Oh, thank you. So practical realities with helping a Black accused person with mental health issues. So systemic issues that impact income level, housing, access to healthcare can present challenges for a person that has come into contact with the justice system. They may not have a plan of treatment or a diagnosis. There's been studies that have shown that Black Ontarians are more likely to enter the mental health system through emergency services or aversive pathways. And if they're coming in to the justice, the mental health system, in emergency, we're thinking about people being in crisis, like people being in very bad conditions. So, this is something that I have concerns about when I'm working with a Black client in the justice system that is in crisis. If there's a tendency, or if there's more frequency of Black people entering the mental health system in crisis, this is something that we need to take and keep in mind when assisting persons in the justice system. So it can impact their the availability of mental health diversion. If they don't have a diagnosis, it's harder to work with the Crowns to get the mental health diversion, and it's harder for lawyers to get the criminal matter triage into a mental health court, because quite often they want to have a diagnosis. And again, if we're seeing that quite often Black persons or Black Ontarians are not getting access to the services, only through aversive pathways, and they're not regularly getting access to these mental health services because of systemic barriers, it's reflected, in terms of how much in crisis they are when they ultimately end up in the justice system at the point of arrest. So if they're very unwell, it can be harder for lawyers to get instructions from clients. And again, it's hard to put together a treatment plan for them. There's a study that has shown that Black Ontarians are less likely to have a family doctor. So that's something else to keep in mind. If it's beneficial to have diagnoses and plans of treatment when a person enters into the justice system, so that you can ensure that they get diversion, that they can get the most positive outcome. If there's a population that is less likely to have access to healthcare and is coming into the mental health system, in crisis, that's something important to consider. Also, an issue is that there are limited culturally appropriate mental health related programming for client referrals. So if you have a person, in criminal court that suffers mental illness, having culturally appropriate mental health related program is beneficial for them. It is a consideration under Crown policies for mental health diversion. But if there's limitations in terms of availability of these programs, that can also impact your client's pathway in terms of getting a diversion. And also systemic issues related to anti-Black racism impacts. So systemic issues such as access to housing, income levels also have an impact on recidivism. In my experience, not having access to housing could lead to backsliding after a person's been released. It can lead to backsliding if they've received a discharge, from the Ontario Review Board, and they end up in trouble again. So, it's important to consider, access to housing, healthcare, and if Black accused persons have limited access, it stands to reason that we're going to see more recidivism from this population and backsliding. So it's an important thing to consider. Furthermore, advancing evidence of anti-Black racism at sentencing or review board hearings can be difficult. You can't rely on judicial notice of anti-Black racism in front of boards or courts. Relying on your client to provide testimony also has its challenges. You might strategically not want to be calling your client to give evidence of how they are impacted by anti-Black racism. So, it can be hard to have a court or a board take it into consideration when you're litigating around issues of anti-Black racism for an accused person that's Black with mental health issues. Therefore, as Kim spoke about, IRCAs or cultural assessment reports can be very helpful in this regard, as well as any kind of studies and reports that can be presented in court or a board. So you're not just relying on your client's testimony or the court taking notice of anti-Black racism in terms of judicial notice. You're actually presenting some figures, some reports, some studies, or a cultural assessment report that's a tool for the court to start taking into consideration the impact of racism for a Black accused person. And just next slide. Oh, I think there's one. Yes. So what can we do to help address this situation? So I think it's important to develop educational and training programs related to unconscious bias and anti-Black racism for mental health and justice service providers. Having said that, I think it's important to remember that can't be a cure-all, and it can't just be merely, a tick box exercise. If there is going to be, development of educational programs and training around anti-Black racism, there should be accountability attached, and it should be meaningful. And it can't be the only, strategy employed to address anti-Black racism in both mental health and justice context. It's important to think about the implementation of race-based data collection in the mental health and justice context. So I alluded to this before, but there is a dearth of data in the mental health and justice context around race. So it makes it harder for policymakers, legislatures, health and justice administrators to address anti-Black racism. Essentially, you don't know what you don't know. So I would encourage participants in this presentation to think about strategies and ways to start developing and implementing race-based data collection. It would go a long way too in helping lawyers if we have studies and reports that have metrics that clearly point to disparities in terms of access to healthcare or differential treatment of Black accused persons in the mental health and justice context. It does go a long way in helping us advance cases and litigate anti-Black racism. Developing and implementing strategies and policies aimed at dismantling anti-Black racism in the mental health criminal justice context is helpful. So thinking about overarching strategies, for various contexts, in the mental health and criminal justice worlds. So if you work in service delivery, just thinking about the implementation and creation of strategies and policies is helpful. And it's important to think about improving access to mental health related services for the Black community, as well as early intervention services. So we talked about, access to social determinants of health, like healthcare, income, housing. If we're not trying to address these wider systemic issues, a lot of the problems that we see in the justice system, can't be resolved. I think one of the key issues or concerns I have is the Black community's access to mental health services. There has been metrics and studies that have shown that their access is limited as compared to the wider population. And that can be detrimental, as I said before, in terms of their pathways in the justice system. Again, if they don't have a mental health service provider before they become in contact with the justice system, it does make it harder to advocate for them because they don't have a diagnosis. There's no plan of care. Again, that makes it harder for lawyers to advocate for them getting diversion or going into mental health court. And also, it's important to think about early intervention so that there's less propensity for Black persons to, have aversive entry into the mental health systems, so that there's less propensity for Black persons in mental health crisis to interface with police and the justice system. So early intervention is key as well. That's it. So I wanted to leave an opportunity for Kim and I to field some questions from the audience.
Okay, well, if there are no questions, what I will say is that I think AJ pointed out all the reasons why it's important for these issues to be tackled at various stages. You know, ensuring that there's access before the person actually spirals and needs, emergency care. Ensuring that there is culturally appropriate and available treatment. We talked about the fact that housing is an issue. And I know AJ, we've done this presentation, a similar presentation to this before, where you pointed out where a lot of mental health services are located, which tends to be the core of downtown areas. And what studies have shown that are not necessarily related directly to the criminal justice system, but quite important, is that a lot of Black and racialized communities, because the expense of living downtown, live in what we call the inner suburbs. So northeast, northwest, and it's difficult to get access to those services. There aren't a lot of services that are local. And so being able to kind of address that, because adding the additional issues of traveling into the core to get services is a cost, time expense, and it really does, as AJ say, impact the ability of lawyers to be able to advocate in the interim, right? And if you see recidivism and a continual increase or escalation of criminal charges, then it does become more and more important for those things to be able to be explained. And so, being able to fill in the blocks and explain the mental health related issues, the reasons for lack of treatment, if there's lack of treatment, does become very important at the back end. But we don't really want people, if we can avoid it, we don't want it to get to the stage where an IRCA is needed. Access to justice means looking at all stages. I think I see a question.
I'll read out the question. So what can regional and local HSJCCs do to enact change and address racism within the human services and justice systems?
That's a very tough question. I think endorsing education, training around dealing with these issues in the justice and healthcare sectors is important. And as well as I stated before, implementation of strategies. So, implementation of dismantling anti-Black racism strategies, in whether your context is in the justice sector or the healthcare sector, is very important. I know, there are psychiatric hospitals that have implemented this strategy. Legal Aid, Ontario has a similar strategy. So thinking about how, your organization or your agency could even implement its own strategies would be, I think, a big step.
I will add to that by saying that it's great to have the strategies, but you also have to, organizations have to hold themselves accountable. And that means developing metrics, collecting data, which means also collecting race-based data. We can't have data that is race neutral, because then you don't actually see the disparities. And we know anecdotally that there are disparities. I attended a session yesterday that I think Anita and the Empowerment Council did. And so we know anecdotally that there's that information out there. So we now need to make sure that we have the data, one, to hold ourselves as organizations accountable, but also to assist counsel to make those arguments at court, and to be able to help individuals on a systemic level, and not just on an individual level.
Yeah, I don't know if I said this, but IRCAs are a really great tool for lawyers to litigate issues of anti-Black racism. So, a very important tool for our toolbox.
Another question along those lines from Jocelyn, a manager of Victor Mental Health Court Diversion Program. How can our program improve our services to support our Black clients?
I think Kim and I was involved in a think tank about improving access to diversion programs for Black accused persons. What I remember in terms of some of the underlying issues is awareness for Black accused persons of diversion is a big issue. So, promoting the programming, I think, is very important in the Black community or for Black accused persons. I do recall hearing that for some people, they're not even aware that diversion programs exist. And just to add to Kim's point, I think it's very important for service providers to think about also doing data collection, race-based data collection. So your demographics. It might help with putting together strategies, policies to ensure access to the services.
One other thing that I would also kind of promote, I think that a lot of diversion programs advertise themselves as diversion programs. They don't explicitly outline that they provide these services for Black communities or racialized communities. I think sometimes you need to, almost like French language services, you need to put that out there so that people are aware and the courts are aware. I will say that, in the consultations that we've had, that Legal Aid has held as a part of the racialized community strategy, what we've also heard is that there might be bias at play in terms of who gets referred to diversion. So, it's great if the court is aware, but it's also, I think it should be made explicit that, you have the ability and you should have the ability, and if you don't have the ability to provide culturally appropriate services, I think that building that ability and then putting that front and center is important.
Thank you. I wonder if we have time for one more question. It's gonna from Niren. Is there any current anti-racism training that you believe work well and resonate with staff? Generally, statistics show that people forget 75% of what they learned 2 weeks after completing a course.
AJ, do you want to tackle that or should I start?
Feel free, please.
So I think that there are a number of different trainings and different organizations that provide specific trainings. And I'm not going to put that out there because it depends on where you are as an organization. Because I think the organizational needs will be different. But one of the things that as policy counsel at Legal Aid Ontario that we've looked at is how do we ensure that this training resonates and stays. What we've found is that it can't be a one-time training. It has to be something that is built in the module. So even if it's every year, you're expected to take training. The other thing that we do is we develop training that is, in my mind, it's baseline training. I think we automatically assume that people are at a specific level, but we're all coming to this at different levels. So you need to establish that baseline, and at each year, or if it's not each year, if you can do it more frequently, build on to that level of training. And the training needs to be made mandatory, especially for people that are coming in or people who are changing roles. That's how our organization is tackling training, and I think it's something that would also work in the health sector.
I 100% agree with Kim.
I think we've reached the end. Thank you, everyone, for questions. I want to say a sincere thanks to Kimberly and AJ today for your presentation. It was very powerful and thought-provoking. It had me reflecting on the work that we're doing with the provincial HSJCC to address anti-Black and anti-Indigenous racism. I think there's a lot of pieces there that we can build on, and that hopefully we can, develop a framework that is adaptable to regional and local committees, but ask them to reflect on their organization and how they can begin to address some of these pieces. So I think it's fantastic. It's a great segue into the lunch hour because we have a networking session at 12:30 on addressing anti-racism strategies. So for folks that are thinking about joining that one, you can log on at 12:30. Thank you everyone for participating in today's session. We're taking our 60-minute lunch break. I encourage you, of course, to connect with your fellow participants, view poster presentations, and our exhibitor booths. A reminder that this was recorded and it will be available on the platform. We have a pre-recorded mindfulness session as well on this website for those that want to enjoy some meditation. Enjoy your lunch, and we'll see you back at 1 p.m. for our keynote session with Carrie Gladue. Thank you, everyone.
Thank you.